Good morning, Your Honors. May it please the Court, Ashley Allen on behalf of the defendant appellant, Mr. Pedro Vasquez. In this case, the parties actually do agree.
Counsel, could you aim the
Sorry,
limit?
a little
Thank you.
shorter. The parties actually do agree about some of the issues in this case. One being that there was an issue of racial or ethnic bias that infected the jury deliberations. There was multiple credible reports about it, and that the judge did not go far enough in his inquiry to determine one way or the other whether the two jurors were involved, whether they remained impartial, and whether the 9 remaining deliberating jurors remained impartial.
How do we deal with, as a practical matter, that you got exactly what you asked for, and now the judge gave an opportunity to hear from the attorneys. The Commonwealth is the one that was jumping up and down saying, let's excuse these folks. And the defense said no, and that could have been a tactical decision. How do we deal with that?
So a few answers to that. One, I don't think it can be a tactical decision in this case. Both the court as well as the counsel were operating without the benefit of this court's decision in Ralphar as well as Keeley's. And based on the record, it seems like they were actually operating not even on Tavares, but a different case that had nothing to do with racial bias. So I would say, if it was a tactical decision, it was unreasonable, and it may have also been ineffective assistance of counsel to not have objected. But even if it wasn't, even though they didn't object, that just gets us to this being not structural error, that was waived, and that this is a substantial risk of a miscarriage of justice standard. And so one of the considerations on whether or not it's a substantial risk of miscarriage of justice is whether it was a tactical decision. I don't think it was a tactical decision based on.
Couldn't it have been that the defense attorney wanted this juror?
I'm sorry.
It could have been that the defense attorney wanted this juror to remain.
He may have wanted juror 2 to remain, but I don't think it was any benefit to any party to keep juror 4, who may or may not have been racist. He had said things to juror 2 that name calling, labels that were given to juror 2 in front of the other juror members as well as outside the courtroom. So while the court did inquire about what occurred outside the courtroom, he never went into what statements were made in front of the other jurors. And he also did pointedly ask juror 4 whether or not the disagreement between the two jurors had anything to do with the substance of the case. He said yes. And even after that, didn't go further to decide to determine what statements were made. And without knowing what statements were made, we can't know. It was on its face, the statement. So
we're speculating. We don't know what the result would have been if juror 2 and/or juror 4 would have been removed. Right?
Would have been removed.
Yeah, we don't know if juror 2 would have been removed as well.
Right, and that's the problem with waiting until after the fact to raise this issue.
Right, that's the problem. But
Right.
I guess the issue I've got is when you say it wasn't a tactical decision, I'm not so sure that the defense attorney wasn't basically making a tactical decision because he liked the composition of the jury as it stood.
And that's where it would be my argument and position that it was an unreasonable tactical decision. I think looking back at this.
But this is one of these heads you win, tails I lose situations. He gets to not do anything, and then.
And that's just one consideration of the substantial risk analysis. And so if we also look at the nature of the error and the significance of it, I think that also gives you some context to look at whether this was a tactical decision. I think that the nature of the error and significance it can't be understated. If there was one juror on that jury that was racist towards whether it was to the defendant or to another juror or to a witness or to the court or to the DA, as the Commonwealth argues, then that was not a fair trial. He was denied a Sixth Amendment right to an impartial jury, and to then put the burden on the defendant at post-verdict to say that you need to now raise this in a motion for new trial when it was raised pre-verdict.
How do we take into account on the substantial risk analysis the fact that there was a second-degree conviction?
There was
that the person was convicted of a lesser included offense. Does that weigh into it?
Well, I think it weighs into the Commonwealth's whether or not they had overwhelming evidence. And here, I don't think they had overwhelming evidence. They didn't find that it was a first degree. They gave a lesser included, and it was circumstantial. There was no direct evidence, and based on
Is the difference between first and second enough to be able to make that argument? I mean, I could say if they can't pertain back on manslaughter, but is that enough to say that the strength of the case wasn't that great because they came back on a 2 as opposed to a 1?
I think it comes down to the jury decided it wasn't a first degree and it wasn't overwhelming evidence of guilt. So they considered it. But
Wasn't there a video showing the shooting?
the video that was submitted into evidence was a grainy video. It does not show.
But you can hear the victim asking Pedro for the keys, and you have testimony, I thought, and you know the record better than I do, of people who were familiar with both the victim and the defendant who said, yeah, that's them.
And so there was much contention about the voice recognition testimony there. It was people who were familiar family members of the decedent who testified. And Pedro is a very common name. So there's testimony that they said that they were familiar with that voice. I think that there was some credibility and impeachment evidence that came in. But again, one factor of the substantial risk is and you have to consider those in totality. And I think that here, and what this court said in Ralph R. is the nature of the error it's can't be understated. I mean, that is overwhelmingly should be weighed most in this case. And so the Ralph R. didn't get into the factors of
Before you, I don't see what the judge could have done without probing into deliberations here. The judge asked you questions. All we have for the basis of racism is juror 2, who's a volatile figure, says the other guy's racist, right? He just says it. What more can the judge do here? Because the judge is walking a really fine line.
So that's not the only report, though. The foreperson wrote in their note that there were multiple statements made. There was statements of preconceived bias, and
Preconceived bias, right? Not go ahead.
that was one report, and that based on what had occurred in the jury deliberation, the other 9 jurors you can infer that they were infected or at least affected in some way where the foreperson said how uncomfortable they were, that there was a lot of tensions in the room based on the statements that were made. And then when further inquired by the judge, juror 2 also said that he didn't just come to that conclusion based on one statement that was made. It was based on multiple statements that were made to him by juror 4 and a label that he gave him in the jury deliberation in front of the other jurors.
When it's in the appeals court decision and discussed in the briefs, when juror number 2 was originally impaneled, was there some discussion that he had a beef against the prosecutor's office or prejudice against the prosecutor's office?
So that came up during the inquiry once this came to light. The prosecutor had gone to the judge and said, oh, we have information that he had sent an email to the DA's office at one point in time, and he was disgruntled about how he was treated.
Okay.
It was within a job or something.
I tried to look at impalement. I couldn't find it.
No, it was in transcript 16, that information. But what I would say to that is the judge heard that information. He considered it, and he didn't find that the statement was not credible. He didn't find that this juror wasn't credible. The problem is that he didn't have enough information to make an impartiality finding.
Going back to Justice Kafker's question, though, what's your position on the questions the judge should have asked at that point, and specifically where a juror has said, yes, it had to do with deliberations, and then a different juror says there were multiple comments during the deliberations? Is it your position that the court should at that point inquire about substantive discussions made in deliberations? And if so, what guardrails should a judge put on those questions?
So I think this is discussed in Ralph R. as well as Tavares, where it's a delicate process. You do need to find out, though, what was the quote?
Ralph R. does say it's a delicate process, but it doesn't say a heck of a lot about precisely what is permissible to ask and not permissible. So what is your position here with the facts, the very concrete facts we have here? What kind of question should the judge have asked?
He should have asked what statements were made and what was the label that was given to you. Because I think without knowing that information, without knowing the content and the context of the statement, he can't determine one way or the other if the impartiality finding is based on the facts or whether juror 4 is being genuine and saying, I'm not racist and I can remain impartial.
Counsel, did you say at the beginning of this that both sides agreed that more should have been done? Okay, and I can ask the ADA, but if that's the case, can you just go through the substantial risk analysis?
Yeah, so our position is you get to the substantial risk analysis and consider the strength of the Commonwealth's case and the 4 factors. The Commonwealth's position is that we shouldn't get there, that this should be remanded to the trial court to further develop the record about what statements were made and whether or not all jurors remained impartial. So I take issue with that because that would effectively overturn what this court has said in Ralph R. as well as Keeley's, where they declined to do that. There's a fine line, or a bright line, I should say, which there's not many of those in law. Pre-verdict versus post-verdict. In pre-verdict cases, the judge is in the position and has the opportunity to make certain that there is a right to an impartial jury. Once you put, after the verdict, is now the burden's on the defendant to then question jurors, bring them in, get an evidentiary hearing, and recreate the record. When the judge, it fell on the judge's shoulders at that point in time, and the inquiry should have been triggered. So that's their position. I don't agree with it. I think this court can handle it sufficiently and remand to the court, vacate his conviction and remand to the court. For substantial risk, it's what I was previously saying is I don't think that there's overwhelming evidence of guilt that overcomes the error in this case. If there is one juror that sat on that case, the amicus brief really touches on this, is the credibility determinations were made. The jury was infected. I don't think that we even need to get to that point. I think that we're on now to the degree in which the jury was infected.
But when we look at the Azar factors, right, when we look at Azar factors for substantial risk, we go to the nature of the error. And one thing the appeals court decision says is, unlike Ralph R., there doesn't appear to be in this case a racial issue as there was in Ralph R.
So that I think might be why this court allowed further appellate review, because
you never know.
I never know. But I think that was an egregious mistake by the appeals court. They actually said that the defendant in Ralph R. was Black. He wasn't. There's a footnote that says he was Hispanic, and that's how they distinguished this case from Ralph R. Is they said, well, that had to do with a juvenile who was having issue or was Black and dealing with the Boston police. There's a footnote that says that he's Hispanic. I don't know where that came from.
One can be Hispanic and Black, but be that as it may.
Right, but the footnote says that, and for them to make that distinction and say that this case is different, materially different based on that, I think is problematic.
I think the appeals court was perhaps suggesting that race was part and parcel of the substance of the case.
I would disagree with that characterization of Ralph R. I think that the issue was whether or not there was an impartial jury, and without inquiring further, we don't know how it affected the case. And so whether it had, and in this case, I think it goes further to say that they said that the dispute between the jurors that had to do with one juror being racist had to do with the substance of this case. I think we have more information, and the problem is actually worse in this case than in Ralph R.
But you agree that we have to apply the Azar factors. Correct?
I do agree with that because, again, same thing as Ralph R. They didn't object to it. They waived structural error, and that's why we're on the substantial risk of miscarriage of justice standard. And so I don't dispute that. And I think Ralph R. had a lot to do with whether or not there was structural error or whether you could waive that. And here we're not arguing that. And if I have no further questions, I rest on my brief and the brief of the amicus security. Thank you.
Thank you. Attorney Shepard Britt, I'll call you to the podium once again.
Good to be back.
I'd like to ask you a question about the Montgomery case. I'm kidding.
Sure.
Can I ask you, I do have a question.
Yes, sure.
Is it right that you changed your view of the case when you argued it in the appeals court and now?
Yes, because I reread the transcripts and realized that because when I briefed it at the appeals court, the case seemed a lot like Ralph R. to me, and then when I went back briefing for this court, I started to see the real differences in the fact that we know who the juror with preconceived biases was in this case. It was juror number 2, because I think that's clear circumstantially that juror number 4 said, this person has had disagreements with other jurors, and it got heated between us and some other people in the room. And you have the 4th person saying the person with preconceived biases has had trouble with a lot of other people in the room. So I think here you can see that the juror with preconceived biases is juror number 2, and we know what his bias is. He doesn't like the DA's office.
Okay.
Where does that come from?
That comes from the when the prosecutor came up at sidebar and showed the judge the email and discussed that the individual had a very negative history with, well, from his mind, a very negative history with.
Was the email introduced as
I was marked
for
S for ID.
It was marked for ID.
Yes.
So he wasn't racist? That was not the issue at all?
Well, juror number 2 was accusing juror number 4 of being racist.
Okay.
Juror number 2 was the one who had a history with the DA's office.
But isn't the problem that the 4th person was never asked about the preconceived biases that he or she mentioned in the note?
It would have been a problem if we couldn't figure out who she was talking about, because if it was a possibility she was talking about juror number 4, I think it's more of a problem. But I think it's pretty clear that you have the one with preconceived biases has had trouble with other jurors. That's what juror 4 says about juror 2. Where juror 2 says he only has a problem with juror number 4 because he called him what he called him. But what he called him wasn't inherently racial.
But what do we do with the fact that juror 2 specifically says that the disputes between juror 2 and juror 4 that took place in the jury room did have to do with the substance of the case?
I don't know that the problem is that I don't think that that's a problem, that they had a dispute about the substance of the case. And I don't think that even if one juror calls another, POS, that you have a problem with deliberations.
Well, the juror 2 specifically said, he said, and in other words, I don't want anyone to think that I'm just calling this guy a racist because of one thing he said outside.
Right.
When we had the fight outside. Rather, I formed the view that he was racist because of comments that he made in the deliberation room having to do with our deliberations. And then he further elaborates and says, like, lots of people think I'm a POS, including people of my own race, but this was not just me being a POS. This was like racist. I mean, he spells it all out really clearly to say, like, there was a dispute. I perceived that this person was racist based on multiple comments in the deliberation room related to the case.
Right. Well, the judge wasn't required to credit him, and I think he was not credible. And I think it shows you have repeated instances where he's telling a different story than everybody else. You have the incident with the Hispanic juror early on during the case where he says, oh, this guy said that he dated the defendant's sister, and brought the juror up and goes, I didn't say that. First he says, I don't like somebody. So I think at the beginning you see the juror number 2 is trying to cause a problem. And I think you see that throughout this case. The juror number 2 is trying to cause a problem. And the defense attorney saw that and said, I don't want anybody to talk to them. I just want to send them back in the room, because he knew that he had a juror who was causing trouble and had a grudge against the DA's office. So he tactically said, I don't want to get into it, because he suspected, and I think it would be borne out were there to be an evidentiary hearing, that the person who was causing the trouble was juror number 2, and it had nothing to do with race.
So the problem is speculation, right? Because the trial ADA appropriately said, let's have an inquiry, because we want to know how this is impacting all the other jurors. But then the defense attorney doesn't want it, and the judge ultimately doesn't have it. Is that why you're looking for a remand?
So that was why I asked for, in the alternative, for a remand, because The Sixth Amendment isn't at play here because this is a claim of invited error. So we're under the Massachusetts Constitution here. But I think that if you think there's a possibility of a substantial risk, we should do the inquiry that the defendant objected to and that the Commonwealth was asking for to begin with. The defendant requested and received juror contact information. According to the status reports filed in the appeals court, he investigated a motion for new trial and sent an investigator to speak with the jurors, and then no motion for new trial was filed. And I think that that's probably because what we strongly suspect and what I think the record shows is that there was no racism in the room and it was juror number 2 was a problem. But if we want to go back, if the court says, look, there's a problem here that needs to be addressed, Commonwealth has preserved the right to have that inquiry. And in Laguerre,
Isn't it kind of late to have an inquiry? Was it 4 years later of jurors?
I don't think that it is, because this was a dispute that nearly came to blows, where one said to the other, juror number 4 said he was trying to get me to punch him. And juror number 2 said that he said, let's go to the parking lot and I'll be your, for you. That was, he said, juror number 2 said that he told juror number 4 that.
This is an inquiry into extraneous factors like in McGowan.
Correct. So we're asking for, if the court is concerned of a substantial risk, Laguerre says you could remand for these. Now that was a post-trial allegation of racism, but there's no reason it can't be, and I'm going to bet that these jurors remember this.
It seems a bit odd because of the procedural posture and the standard of review, right?
Right.
There's either a substantial risk of miscarriage of justice or there's not.
Right.
Are you aware of an analogous case where, when we're in that standard of review, we would be remanding for a hearing on whether?
Well, so I don't think that there isn't case law on it, because if the record is unclear, then there's no substantial risk.
That is my question.
Right. So if the record is unclear, then the defendant hasn't met his burden and you can simply affirm. Now, he can still go and file a motion for new trial. And that was the position that we've taken, that we certainly took by the time we were in argument at the appeals court. Absolutely, he can still file a motion for new trial and raise that issue. But if the record is insufficient, it's the defendant's burden to make the record. And he specifically, and I would argue tactically, didn't make a record because it wouldn't have been good for him. If there are no further questions, I'm happy to rest on my brief.